At Jackson Water, we are in the game and locked in on our goals. Every day, our dedicated teams are hard at work, ensuring that clean, reliable water flows to every home and business in Jackson. We are not just fixing pipes. We're investing in a brighter, more resilient future for our city. Jackson Water. Water for all the time.
All right. Hello, everyone. Thank you so much for joining me for WLBT Plus. My name is Kara Shirley, and I am your digital news desk host. I am joined today by the Rankin County ADA, Miss Kathryn Newman. You probably recognize that face, seeing her there. She was the prosecutor in the Carly Gregg trial. And so, Kathryn, thank you so much for being in here with me today. I know that, let me make sure I've got all of my audio working. There we go. All right. So let's talk. And I asked you this question right before we came on air, and I want to ask you it again real quick. How did you get the Carly Gregg trial?
So our office actually, excuse me, each attorney kind of handles a specific set of crimes. I handle crimes against children, all the sex cases for a certain part of the alphabet, and then I took over the murders in January. And so, of course, her case came in after.
Yeah, I started here with WLBT. I started here in March. Actually, I started March the 6th was my first day. So, like, this was very, very new, very fresh, me seeing that and being here in this area. And I almost, when I watched it at first and heard what happened, reporting the story and everything, I was like, "What have I moved into?"
Yeah. 'Cause it was March 19th.
Yeah,
Not been
not long at all, and it was really kinda scary, um, just to hear, it's just to think that a child could do that to their mother. That I think is the part that was the most terrifying, is that a child could do that to their mother, a seemingly, um, brilliant child. I mean, she was a brilliant child. She is a brilliant child, high scores on the ACT at the age of 13. I don't know that I ever took the ACT.
Well, I did, and I did not ever make a 30 on
Really?
it. Yeah.
So
Yeah.
it is crazy. So let's see. I've got going in and out. I'm talking about your audio. So what I'm going to do, because this is live and in real time, I'm going to get Keith in here to see if he can fix your audio, make sure that it's working okay. If you guys still have issues with her audio, please let me know. And I'm watching your comments. So we are live now on Facebook. We're live on our website. And if you are tuning in on any of these channels, TikTok, we're live on our TikTok channel as well. Thank you all so much for tuning in. So Carly Gregg, in case you are tuning in, you don't know, Carly Gregg is the then 14-year-old, now 15-year-old, who was tried for murder, for killing her mother, and for attempting to kill her stepfather, and then tampering with evidence. And Kathryn here is the ADA that prosecuted her, and was very successful in the eyes of the law. I guess it was a successful case, but when you think about it, you take a step back and you look at what happened. There's no winners in this case. There's just no winners.
That's right, Kara. That's exactly right. And maybe if I talk a little closer to this, that'll help. We have talked about this. Both Michael Smith and I have said that pretty much anytime somebody talks to us about this case is because every case I have is a violent crime. So that means there is a victim of a violent crime. And so for me, no one wins in that instance because you can't make them whole again. You know, this family lost Ashley Smiley, and now they've lost Carly Gregg because of her actions. So, I mean, they actually lost two family members. And so it's even sadder than normal because if you have, a defendant who's not related to the victim, you have two separate families that have been affected by a tragedy. And in this case, it was just a very large family that was affected by her actions.
Right. It's so sad. And then, I mean, you even think, I'm sure maybe a lot of people don't want to think about this, but then you got Kevin Gregg, who is Carly's biological father. And I mean, even though they did not have, according to what was reported in the trial and things, didn't have the best relationship, he's completely lost his daughter, you know.
Yeah. So I think before she committed these crimes, I think it had been about a year or a year and a half since she had spoken to him. But that doesn't mean he stopped loving her, right? I think even in his interview with you guys, he's like, I still love her. I hope she, gets right, but I still love her. And so you're exactly right. I mean, there's her dad, there's Ashley's parents who are her grandparents, there's Heath's family. He and Ashley were married almost 4 years when that happens, but still his mother was pretty close with them. I mean, there's definitely a whole community. And then that doesn't even take into effect the children that went to Northwest Rankin. So Ashley Smiley was a teacher and from all accounts was a beloved teacher. And so they kind of closed her classroom down for the rest of the year and made like a makeshift memorial for her. I mean, so you have all these other innocent children who were affected by a terrible tragedy.
And then on top of those and all that we've already spoken about, you talk about the friends of Carly, who, especially the friend that came over, that she got to come over. I think as a parent, while I do feel for the child that came over, the friend, I also feel for that child's parent, having the thought that you were the one that dropped your child off into that traumatic situation and not knowing. I mean, obviously the parent didn't know, but there's so many people that are touched by this.
That's right. People. That's right. And their lives will forever be changed because of decisions that were made. And, we unfortunately talked to that child and her parent and explained to them, like, you had no way of knowing. If you had known this, you wouldn't have taken your child there.
Right.
And unfortunately, if it wasn't that friend, it probably would have been some other friend too.
Right. And so let me ask you the question real quick, because I know a lot of people have asked this and brought this up. Why was that friend not charged with anything? Because she was there. Carly told her what was going to happen. She showed her mother. When Carly told her friend to go outside because the stepdad was coming home, she could have ran and got help then. So what is the I guess the situation looking into that?
So first of all, the state of Mississippi, it's the Milano instruction, and there's case law that says there's no duty to intervene in a crime. So that's whether it's an adult or a juvenile, right?
Wow.
So no one has a duty to intervene. So from a legal standpoint, she was never going to be charged. But from a common sense standpoint too, I mean, we have another juvenile who's gone over unknowingly to a house she thought she was going to help her friend at, and then she greets her at the door, "Are you squeamish around dead bodies?" And then tells her what we've all heard, like, "I put 3 in my mom, I got 3 more waiting for my stepdad, do you want to wait outside while I take care of him?"
Wow.
But she had a loaded gun. I mean, and while she has this loaded gun, at some point I think the friend, and I can't remember if she testified to this or not, but may have put it down, but shows her other guns that are in the house. And so I'm 40 years old, and there are a lot of things I would do if somebody had a loaded gun.
Yes.
And they told me to go do something.
Right. If I walked into the house and the 14-year-old, I'm listening.
Yes.
I'm listening, especially when they've already proven to me that they're not above committing a crime.
Killing their own mother.
Right. Exactly. So that's a good to know as to why the child or the friend, she is a child, was not charged with this, because she didn't do anything wrong.
That's right.
So
the only thing she was guilty of was being a good friend.
Yeah. Bless her heart. She may question that going forward. I think of the trauma on these kids, and it breaks my heart. It absolutely breaks my heart.
So sorry to interrupt you.
No,
I do want to say this too. That's one of the things that when we talk to the parents of children like that on any of our cases that involve violent crimes, we recommend they get counseling or therapy in some way. We say, hey, we'll help you get her in touch with somebody, get him in touch with somebody, whatever the circumstance is. And some places will provide family counseling as well. And so, I mean, just because the trial is over doesn't mean the trauma is over for all the people that were involved in it.
So you said in some cases the state will provide counseling in situations?
Yeah. So if you're the victim of a violent crime, we can through the Mississippi Attorney General's office. They have the Victims Compensation Fund. And so they provide funding for these people to actually go and get therapy, counseling, whatever it is they need. Sometimes those that are a little bit farther removed might not qualify for those services, but we certainly have people that we can recommend for them.
Right. So then her stepdad, Heath Smiley, he would then qualify for that because he was a victim.
Yes, absolutely. And when I spoke to him on the phone, I explained to him that process and asked him to fill out the application and told him, whether he thought he needed it or not. It was always good to file the application. And so, yes, he has the ability to get those services.
And that's good to know. That is good to know. Let's talk then, since I brought up Heath, let's quickly touch on this because I've heard you talk about this in other interviews, but I want to touch on this because I know a lot of people have asked, was there something inappropriate going on between Carly Gregg and Heath Smiley?
We have no information to report there was anything improper other than Heath being a loving stepdad. So law enforcement had Heath's phone, law enforcement had Ashley's phone, Carly's phone, her burner phone and her regular phone. Okay. Carly went to, as we heard in trial, Carly had been in therapy or counseling even since before she knew Heath Smiley, never reported any sexual abuse, never reported it to any friends, and then was interviewed by a psychologist and 2 psychiatrists and never mentioned anything about sexual abuse. So no, there is nothing to indicate that there was anything improper going on with them.
So that, because I've heard a lot of people ask the question, well, there could have been a phone that was hidden that they didn't know about or things like that. So even the hidden phone from Carly they had.
Yes, that's right. That's right. So her actual phone that mom and stepdad knew about, they had taken that phone at some point, and so she was communicating with her friends on the burner phone. And the messages that you may have seen that were introduced at trial, those all actually came from her burner phone. So yeah, that was the secret phone. So again, assuming if something had happened, she would have certainly had more information on that phone than the one they had access to.
And what did they search the house? I mean, I know that's wasn't their first thing in their mind that what they're looking for, but was the house searched and there was nothing found in the house that would indicate something like that happening?
That's right. So I don't know how much of this we're supposed to talk about, but since we're live, there was one sexual device found in Carly's room under her mattress. Law enforcement, because they want to rule out any possibility, right? We're not assuming that he did anything, but they're like, hey, we want to do our job. That was sent to the Mississippi Crime Lab. The only DNA that was found on that belonged to Carly Gregg.
Okay. Well, that's good to know because I know that I'm sure you have seen that or heard that, have been asked that a lot.
Yes.
Is that happening?
Yes.
And, I know a lot of people want to look at a stepdaughter relationship and maybe side eye it a little bit. But my husband is my oldest daughter's stepfather, but that's her daddy. That's his daughter. You know what I'm saying? So it's like, I understand the love that a step parent can have for their child. While it may not make a lot of sense to people, especially with him being shot by Carly and Carly killing his wife, I can see the support.
That's right. And, it's the only daughter he's ever known. And every human being processes trauma differently. And so while his reaction might not be mine or yours, it's his. Yes. And there's no playbook on how you're supposed to respond in this type of situation.
There really isn't. There really isn't. And if there was one, you would know because you deal with this.
Yes. And I can assure you, everyone responds differently.
Yes, they do. Well, I'm going to ask you another question about, or a question rather, about Ashley Smiley and something. I know you said earlier you don't have a TikTok, so you probably have not seen this, or maybe you have, but people have been saying that they can hear in the video, the security camera footage, after the shots are fired and Carly is in the kitchen and she's texting, that they say that you can hear Ashley say, "Help me." My question to you is was that a possibility with her injuries?
No. So I've unfortunately watched that video numerous times. When you watch it and turn the sound up, you hear Carly shoot, you hear Ashley Smiley scream, you hear Carly shoot again, you hear a thud, which we believe, based off the trajectory of the shootings and the casings, that's when Ashley fell and hit the ground. And then there about 4 seconds pass and you hear another gunshot. There was testimony at trial by investigator Burnell that there was stippling in this gunshot. And so that means that the gun was in 3 feet of her when she was shot, 30 inches actually, so a little less than 3 feet. There is no way. One of those projectiles was lodged in her brain and one was lodged in her neck. So when I watched back through that video, Carly's texting, and we know now she's on Ashley's phone, texting with Heath, "When will you be home, honey?" And then Heath responds, "It'll be a little while." And I believe what she says is, "Oh, that's great." And then hits the thumbs up button. And so then she starts humming. And so I think it's actually Carly that people are hearing, and not Ashley.
Because I mean, I listened to it and I was like, well, if someone is implanting that thought into my brain that she is saying that, it could sound like that. But I was like, you're the perfect person to ask because you would know for sure.
Yes.
So let's talk about now with Carly being a minor here in the state of Mississippi. A lot of people don't understand, why was Carly given such a quote unquote harsh sentence?
So in the state of Mississippi, any person over the age of 13 that commits certain crimes, murder being one of those, the use of a firearm also is one of those crimes. There's certain qualifying offenses where you are automatically considered an adult. You don't have to go to youth court to be adjudicated up. And so murder, particularly murder with a firearm, is an automatically certifying event, meaning that in the eyes of the law, because she was over the age of 13, she is considered an adult. And so in July of this year, the Mississippi legislature changed the sentencing scheme for a juvenile convicted of murder. It used to be life and only life. And now the sentencing range is between 20 and 40 years. And again, that as of now, that's a day-for-day crime, but between 20 and 40 years or life if affixed by a jury. And so the sentence that Carly Gregg received was within the sentencing guidelines for murder. For attempted murder, it is life if affixed by a jury as well. And so that's why she got the 2 life sentences. And of course, Judge Arthur ran them in legal words concurrently, but in layman's terms at the same time.
So tell me, what does that mean then for Carly? Because she got life without parole. Does that mean she is literally never going to see the outside of prison, or how does that work?
Yeah. So as the law stands right now, yes. And so we talked about this just a little bit before we got on the air. Technically, the murder statute does not differentiate between life with and life without parole, because the parole statute specifically prohibits murder from being a parole eligible crime. So it says you can't get parole if you're convicted of murder. However, after Miller v. Alabama, the U.S. Supreme Court came in and said juveniles could not automatically be sentenced to life without the possibility of parole. And so during our sentencing, we had the jury consider for both the attempted murder and the Miller factors. And they ultimately found what we'd asked them to do, and that's to hold Carly in prison without the possibility of parole. We think she's a danger to society. And so, again, that's within the sentencing guidelines. If she had been charged with capital murder, they would have been able to consider that. And so when we were looking at it, we were like, well, it's better to err on the side of caution and give them the option of the possibility of parole than to have it come back on appeal and them say, well, you guys should have given the jury these 3 options.
Right. So you're just basically just covering your bases, making sure that you're making it appeal proof, I guess.
Yeah, trying to, yes.
So let's talk about the biological father, because we heard his name a lot during the trial. We've heard his name a lot in the appeal. But let me ask you, why was Kevin Gregg not subpoenaed or not asked to testify, whether it be for the state or the defense? You probably can't answer it on the basis of the defense, but why was he not subpoenaed?
So the state never had an interview with Kevin Gregg, right? He never came to law enforcement. Excuse me. He never responded to, I personally did not reach out to him. But both the psychologist, Dr. Manu Gugliano, and Dr. Jason Pickett, the psychiatrist, attempted to reach Kevin Gregg multiple times in order to try to get a statement from him about any mental health history that he knew. I mean, that's the primary reason for talking to him. From our standpoint, Carly had not talked to him for a year and a half. So as far as proving her guilt, there really wasn't any reason for us to subpoena Gregg to the trial to talk about something he didn't know about. And so that's why we personally didn't reach out to him. I did have conversations with the defense attorneys, and, they said that I think that he had harassed them, and so they had blocked him or something to that effect. So I can't say why they chose not to call him, but maybe it was based off the conversations that they had that I was not privy to.
Right. Well, I mean, we've heard them talk about that there was no, or that they couldn't get in touch with him or something, but then we've heard saying that they did talk to him before. So I'm not sure. I guess I would need to speak with Bridget Todd.
That's right.
Find
Yeah.
out
I
about
can't.
that.
Yeah. I can't answer for them. I can say that I personally did not reach out to him, but both our doctors did in an attempt to try to see if he could provide any helpful information. One about his medical history, and two
Right.
about hers. And so that was another thing that I had specifically asked from the defense. Hey, do you have any medical records for him? Give me anything you got on him. You know, our doctors want them. We want to make sure that we have a full picture. And the only thing that we were provided, which is what was introduced at trial, was like 3 pages. A psychiatrist, I think, that he saw in the course of the divorce between he and Ashley Smiley.
Okay. Well, that's good. So y'all you didn't see the need for him, not in a rude way.
Yeah, that's right.
Yeah.
Right. He just could not provide any relevant testimony. I mean, my job was to prove, right, once we got the case, to prove that on or about March the 19th in Rankin County, 2024, Carly Gregg did kill her mom, did attempt to kill her stepdad, and to tamper with physical evidence. And throughout the course of the investigation, it was learned that Carly had not spoken to him for a year to a year and a half. And so we knew he didn't have anything to do with it, and we knew he didn't know anything about that.
Right. I know when we spoke with him, he said that he did talk with Carly. When she was in jail, she called him, that they had texted for a while, and that according to Kevin Gregg, that Bridget Todd had put a stop to that. My question in this, and is his stating that, and maybe you can shed some light on it, is if Kevin Gregg and Ashley Smiley did have joint custody of Carly, should he have not, once Ashley is no longer living, the custody would have fallen to him. So why, I guess I'm wondering, why was he not involved in the picking of her attorneys or anything like that? Can you speak to that? And you may not be able to.
So I can say I know by looking at their custody agreement that they did have joint legal custody. So meaning that he still had legal rights over Carly. His rights had not been terminated, but Ashley had physical custody. And so you're right. After Ashley was killed, there was no longer anyone to exercise physical custody other than him. However, it's sort of weird. In private practice, I did some chancery work. So in a typical situation, take aside the fact that somebody's committed a crime, then yes, usually what would happen is that bio dad would petition the court then and say, like, I need physical custody as well as legal custody. In the eyes of the law, on the criminal side, Carly Gregg was an adult. And so no one but her has the ability to say who her legal counsel would or would not be. And in the eyes of the law, she alone has to make the decision on whether she pleads guilty or not guilty and goes to trial. And so to talk kind of a little bit about that too, Kara, I know there's been talks about the fact that Carly Gregg wouldn't have qualified for a public defender. And I've spoken about this before. She had a public defender. There was a public defender assigned to her before Miss Todd and Kevin Camp entered an appearance. And so just to put any end to that, she absolutely had a public defender. And then at indictment, she would have been assigned a different public defender if she requested one. I mean, certainly a 14-year-old and 15 at the time who had no assets qualified for a public defender. And the ones that we have in Rankin County are excellent.
Yeah. That's good to know, because it was brought up, it was mentioned, and the question has been asked, if she has no assets, and how is she affording the attorneys? Now, of course, in other interviews, Bridget Todd has stated that they did it pro bono, which great. That's awesome for them to do that, step up to do that. But they also said that she couldn't get a public defender, but she could have. She did have one.
That's right. She had one. They entered an appearance, and so a new public defender was not assigned to her at indictment. So what happens is if it comes from the sheriff's department, it's a little weird in our county. So if it comes from the sheriff's department, it originally goes to county court, and so that's where she had a public defender assigned to her. And then once a case is indicted and it goes over to circuit court, then there's a separate public defender that would have been assigned her case. But at no point would she been left without representation.
Okay. Well, let's talk about the guns now. So with all the school shootings that have happened and all the kids having these guns and getting into these violent situations, violent crimes, we hear a lot about parents being held accountable for it, whether it be because they knew the child had issues or they had left the guns out in the open for them. Now, obviously, with Ashley being deceased now, can't hold her accountable for it. But Heath Smiley was a parent too in the same household. if they knew that she was having some type of emotional mental health issue by taking her to the psychiatrist and medications and therapists and things like that, could they not be, or could Heath not be held responsible for having loaded weapons in the home of a child that he knew was having issues?
So I think, again, to be clear, the only issues that were reported were anxiety and depression. And obviously, when you have somebody with anxiety and depression, one of the things that you worry about for me would be suicide. And so I, as a parent, I would want to keep our weapons locked up. I'm not aware of any law in the state of Mississippi that requires that, right? So there's certain things like child neglect or child endangerment. You would have to show some injury to the child. And of course, in this case, the child is the one who was causing the injuries. You know, she wasn't the one that was injured. And so, again, I think good practice for any parent would be, you know, to try to keep your firearms out of reach of children, particularly, you know, if there is someone that has mental health history, whether it's anxiety or depression or anything else like that, you know. But I'm not aware of any law that requires that they do so.
Okay. I'm going to jump in. I want to talk about the appeal now, but first I want to look at our social media stream and see if we got any questions here from people. I'm looking. I have to. It's a lot. There's a lot.
Yeah.
Okay. Miss Oceans Small says, I'm late. Has a stepdad's questionable involvement been addressed? And it has been addressed. And if you want to touch on that just real quick, so she'll.
Yeah, sure, Miss Oceans. So as we spoke about earlier, law enforcement looked into any issues that may be at play, right? So they had Carly's phone, Carly's burner phone, Ashley's phone, and Heath Smiley's phone. And, you know, also the benefit of interviews with all of her friends and medical providers. And there was never any abuse suspected or alleged.
All right. Awesome. So it has been investigated and there's nothing. There's
right.
nothing that is apparent now. So let's talk about the appeal first. So the one that was filed by by the defense, it was 9 pages.
Hey, and I want to stop you. I'm sorry.
Okay.
This is just technical. So the appeal is following the circuit court level. So the appeal would be like, if this motion is denied, then that goes up to the Court of Appeals and the Mississippi Supreme Court. So it's just
I
words.
appreciate it.
Yes, it's just legal words. We call things crazy stuff in our world. But so what they filed was a motion for either a new trial or JNOV, judgment notwithstanding the verdict, which just means they're asking the judge to set aside the jury's verdict. And so that's handled there in the circuit court. And then the circuit court judge, Judge Dewey Arthur, can either grant that or deny that. And then if he denies that, then the appeal would take place. So sorry, I just wanted to clarify.
No,
that.
I appreciate that. Please don't let me sit here and sound stupid.
No, you don't sound stupid. You don't sound stupid, you know.
But no, I thank you for that. But so the defense is the JNOV. It was filed and it was 9 pages. Yours was a little longer. It was 48 pages. I have it here, have it all printed off here. So let's talk about this. Let's talk about them alleging that she did not get a jury of her peers. Just talk about that.
Yeah. So, I mean, I guess you make whatever arguments you can find.
Yeah.
And so in the state of Mississippi, you have to be over the age of 21 and able to serve on a jury. And that's pretty clear. There's cases out there that say the legislator can set up guidelines to determine who is a qualified juror, who is a qualified elector. You know, you can vote at 18, but you can't serve on a jury until 21. There is nothing in the law in Mississippi and or the United States and or the constitutions that require that you be tried by a jury of peers at a similar age. It basically says it has to be a proper elector, so somebody that is registered to vote, that lives in that county, and the jury panel as a whole should be made up of the citizens that live in that county that are qualified electors. So there was never a chance that 14 and 15-year-olds were going to be selected for this jury. Right.
And it makes me, I could think too, when I hear that people are concerned about Carly Gregg not being emotionally mature enough to be held as an adult. But then we want to use the argument that we should also have a jury.
Yeah, we should bring 12 of them in.
Yes.
12 teenagers. Yeah.
So I can't imagine that being fair to the children either coming in,
Right.
having to submit them to that trauma. But so peers, I mean, since she's being tried as an adult, those were adults.
That's right. Those are a jury of her peers. They were Rankin County citizens who are qualified electors. And so one of the things I pointed out in our response is at no point did the defense object to the jury panel as a whole. And so there's plenty of cases out there that say, for instance, there are some rural counties where, it comes up where there's a racial question on the panel doesn't have enough of a certain color. And so they can go to the judge and say, Judge, we object to this panel. We don't think it's a fair makeup of our county. And then the court has to say, okay, well, this is how they were selected and has to show that it was at random. So it doesn't necessarily have to be a statistical number of people that are made up of a certain class. But again, age is not a protected class for juries. Religion, sex, color, race, those are protected classes. Age is not one.
Age is not one. Well, let's talk about now they're talking about the equestrian therapy that they claimed that Kevin Gregg spoke about in an interview with us, which he did not. But you're saying, I believe I've heard you say that they had information on that equestrian therapy before the trial ever happened. Is that correct?
Yeah, absolutely. And I even talked about that in our sentencing phase. So when Carly went to see, I'm trying to remember now, I believe it was Precise Neuroscience, when she saw Olivia Lieber there, the nurse practitioner, Ashley and Carly reported to her that she had this equestrian therapy, which for people that are not involved in horses, it's horse therapy, right? They use these horses kind of like as a therapeutic animal. That therapy was related to her parents' divorce. It was court ordered. And then at some point, Ashley even puts in her paperwork, and then Olivia Lieber pointed out that that counseling ceased. Basically, when Carly no longer needed counseling, they stopped doing that. And so absolutely, the defendant knew about that. They knew that she had participated in that. It was referenced there. It was also referenced in Dr. Gugliano's report that they were provided a copy of. And then I believe that their expert also referenced, he didn't specifically talk about the equestrian therapy, but that Carly had received therapy and counseling subject to court order during her parents' divorce.
So they knew it.
That's right.
They knew it.
That's
So
right.
them, and maybe they're alleging that he said that it was because she was hearing auditory hallucinations. But I mean, we know that that's not the case, but
that's right. I watched both interviews. He did not say anything
No.
like that. And again, we had medical records, counseling and therapy records that went back to the time of Ashley and Kevin Gregg at the times, Ashley Gregg and Kevin Gregg's divorce from back when Carly was, I don't remember now, 4 or 5, something like that. She never mentioned auditory hallucinations. Those were not mentioned until 9 days after she had been arrested for murdering her mom and attempting to kill her stepdad.
Wow. So never, not once.
Not a single record of anything about hearing voices, about having lapses in time, about having problems with any kind of voices, any personalities, nothing of that nature. The only thing that was in her medical history prior to that time was anxiety and depression.
So let me ask you a question, a hypothetical question as an attorney. So if they put into their JNOV that this is their wording, that he said it in an unaired portion of our interview, and that did not happen. So because that is in writing to the judge, is that considered perjury? Is that considered a lie to the court, having that particular wording? Because you just talked to me about wording.
Yes.
So could that play out?
So let me say this. So say that was my filing and I had put something in the filing that I later learned was not accurate. As a duty, as an attorney, we have certain rules that we're required to follow, the rules of professional conduct and the rules of ethics. You are to be truthful with the court at all times. So even if it was not an intentional misrepresentation, if I later learned something that I had put in a pleading was inaccurate, in fact, it happened in this case. in my response to their motion to try to exclude a drug screen, I included the wrong federal grant. I said that our youth court was under this grant. And then later, after I'd filed that, I realized that's not the right grant. So we contacted somebody in my office, not me, contacted the Board of Supervisors. We got the right grant, and I filed an amended pleading, right? Because that's what you're supposed to do. So if I had filed something that I later learned, whether it was intentional or not, I would file an amended pleading stating new information has come to light that this does not appear accurate. And just for the record, if I had said something about you guys, I would have been beating down the door out there saying, hey, please take this down until we can figure out what's going on. And so, lying to the court intentionally is a sanctionable action. But again, it does have to be intentional. And so I would hope, based off the situation, the hypothetical situation that you're talking about, that whoever did that would have some justification for why they said what they said, and be able to. Thankfully, they don't have to answer to me.
Right.
They would have to answer to the court on why they had put something like that in a pleading.
And in your rebuttal, you even said, we hope that this was just an error. Like you even extended some grace in your rebuttal. We hope that it was just an error. So you've referenced so many court cases in here, so many. There was none referenced in the defense's JNOV submission, but you've referenced a lot. And I want to talk about the insanity. We know Carly has some mental issues, but she was not legally insane. So explain, I know we heard a lot about the McNaughton, but tell us a little bit more about the McNaughton theory.
Yeah, so I want to talk two things, competency and sanity. So competency, which the defendant said they had never called into question, they actually had. There were, when she had a public defender, they filed a motion to have her assessed for drug and alcohol and also competency. And so there were other times where they had called into question. So competency is whether or not a defendant can communicate with their attorney, whether they have the ability to understand the proceedings and the nature of the crime that they've been charged with. Basically, can they help their attorneys at trial? And so the defense has said, well, competency was never an issue. However, it was raised. And so we had Dr. Amanda Gugliano evaluate Carly, and she determined that, in fact, she was competent, right? She knew what was going on, and she could assist and could remember facts, which was important to us because if you can remember facts, that means you knew what happened.
Right.
So insanity is a defense. So if you're not competent, we could not have proceeded to trial until either competency is restored or somebody then goes out to the state hospital and they stay forever if they're never competent. But she was competent. So insanity, and that's why you didn't hear about it in our case in chief, is because every defendant is presumed sane. So the law says if you committed a crime, you're presumed sane. And basically the defendant doesn't have a burden, but it sort of shifts to them to say, okay, well, this is why this person didn't know right from wrong. So McNaughton is the standard. You have to have a mental defect. And Dr. Pickett talked about this. And he said, look, at the end of his testimony, he's like, look, even if my diagnoses are wrong, right? Even if you believe Dr. Clark and you don't believe anything I'm saying, that gets you to the first step. And that's, does the person have a mental disease or mental defect? So again, anxiety or depression can qualify for that. And certainly Dr. Pickett also found some other diagnoses that he thinks meet Carly, as well as Dr. Clark did. So, right, she gets to the first step, the first hurdle. So then the second step is, did you know right from wrong? Did you know your actions? And we believe that, there was no question about that. I mean, when you watch that terrible video, you see that she knew that was her mom's phone. She knew her mom's passcode. She knew right where the loaded weapon was. She knew what part of the house her mom was in. She had spatial awareness. Dr. Pickett talked about her sitting on the stool and putting the gun behind her, making sure that the dogs didn't knock it over.
Right.
That showed that she knew the gun was dangerous. When her friend comes over, well, first of all, before her friend comes over, she kills mom at 4:14. At 4:16, she starts calling, FaceTiming, and texting with multiple friends.
4:14 to 4:16, 2 minutes. Wow.
Yes.
Okay.
Yes.
I didn't
So
realize
she immediately
that.
kills mom, walks right out into the kitchen. And when she's texting Heath, that's at 4:14. And so then she, takes that phone and the gun and goes out of the camera view, comes back in to let the dogs out. And that's when the camera is ripped out. At 4:16, she starts texting with her friends. Her friend that got over to her house got there at 4:58, text and said, I'm here. So there's this large portion of time where Carly is texting with friends, calling again, and FaceTiming. I mean, this isn't somebody that is just like out of her mind. She's
Yeah.
responding to these people. She's calling them by the right name. She knows their boyfriends and girlfriends' names. She
Mhm.
knows their nicknames. She's telling them, I effed up. Don't call 911. You can't do that. One of her friends said, don't hurt yourself or someone else. This is on a call. And she immediately says it's too late. Again, she knew what she was doing. And then,
Mhm.
the main thing is insane people don't run because they don't know that what they've done is wrong.
Right.
And so we know that she fled the scene once she realized that she, I guess, was unsuccessful in whether or not she killed Heath.
Yeah. I like when you just pause and think about it, it's overwhelming.
Mm.
It is overwhelming to think.
Mm.
I have 2 teenagers. I have a 16-year-old and I have a 13-year-old. And I immediately went home every night I try and hug them. Like, hug them. I love you.
Yes, yes. I mean, and to think like, when you carry that child and you love them so much, that
Mhm.
literally the person that brought Carly into the world, she chose to take her out.
Yeah.
And
seemingly, of course, it's not the state's responsibility to prove the why, but seemingly over vapes.
Something so silly.
So silly. It was, someone said this during the trial on our live stream. They said she made she gave a permanent fix to a temporary problem.
Mm-hmm. I think that's a great explanation of what she did.
I mean, because it's really a permanent,
It is.
assuming that this JNOV doesn't go through. And so let's talk about it again. What do you think, Judge Arthur, after he takes his pregnant pause
and eats his pork chop, right?
Yes, and eats his pork chop, eats his good pork chop every day. Every day in the live stream, people were saying, "What's for lunch today, Judge?" But let's take the pregnant pause, and that moment was great.
Yeah.
But what do you think? How do you feel the outcome is going to be based off of what the defense has submitted, what you have submitted? Do you think that he is going to set aside anything?
I mean, when you look at their motion, and kind of one of the first things that I pointed out in my response, Kara, is that their motion actually fails to abide by the rules. You're supposed to point to specific facts and then support it with case law. So they haven't done that. But even taking that aside, the things that they have argued do not entitle them to relief. Right.
Mm-hmm.
I don't think that Judge Arthur should set aside the jury's verdict. So some of the cases that I pointed out in there talk about on appeal, there's different standards of review that the Court of Appeals and the Supreme Court have for different types of cases and different alleged errors by the court. And
Mm-hmm.
One of the things that I pointed out was in an insanity case, which is pretty rare, right? It's rare that a defense takes a case to trial and actually claims the insanity defense. We just
Right.
don't see that a ton. The Court of Appeals and the Supreme Court have said we give the highest deference to the jury on insanity cases because that's who determines whether or not somebody was sane at the time is the jury.
Mm-hmm.
And so they're saying the jury, we believe the jury got it right. And they'd have to show some grave reason on why the jury didn't have all the information to have it set aside. And we don't believe that it should be set aside at the circuit court level or at the appellate level. I mean, we tried to do kind of what we talked about earlier, even in our jury instructions where we gave the jury the possibility of parole. I mean, we tried to do everything we could to make sure that no case is perfect, right?
Yeah.
But that this case did not come back on appeal because we do abide by people's civil and constitutional rights.
Mm-hmm.
And we want to make sure that it was a fair trial. We believe the jury got it right and that the sentence and the verdict should be upheld.
And so we don't have a date yet because now that both sides have filed, you will go back before the judge and he will make a ruling on this, correct?
So there's actually nothing that I'm aware of in the rules that says we have to have a hearing. So
Okay.
sometimes this is pretty typical in every jury verdict case, the defense files a motion to set aside the verdict.
Mm-hmm.
Sometimes the state doesn't even file a response. But usually what will happen is the judge will sign an order denying that. There are cases where they've granted it, of course.
Yeah.
But I don't believe there's any requirement that there be a hearing. So I don't know what Judge Arthur will decide to do,
Mm-hmm.
whether he will sign an order one way or the other, or whether he will set it for hearing. But as of now, no hearing date has been set.
No hearing date. So now we know what to be looking for, what to watch for.
Mm-hmm.
Is he going to Are you going to call y'all back in?
Yeah.
I want to bring up and talk about real quick the Brady violation or Brady
Yeah.
violation.
The allegation. Of a Brady,
Allegation. There we go.
Yeah,
There
of
we
a
go. That's
Brady
better.
violation.
So tell me how you felt in that moment. I just want to know your true feelings in that moment.
I've never been more mad in the courtroom, and I've malpracticed for 15 years. I have done chancery work. I have done, so that's divorces, and those get contentious. I have done civil work, represented people in car wrecks, represented nursing homes. I have been a criminal defense attorney for a number of years. In fact, I was a public defender in Rankin County before I started this job. I have never been so mad, and the reason for that is that the defense was given every opportunity to correct that allegation to begin with. So there were allegations by one of the defense attorneys against myself personally early on.
Mhm.
And so I started documenting everything via email. Said, all right, fine.
I think you've done this before or something.
Yeah. So I started documenting everything by email. We make them sign saying that they've received everything. And so mistakes happen, right? But with a Brady violation, you're saying that basically I intentionally withheld exculpatory information. So something that is going to show that the defendant did not commit these crimes, and or something about an important witness that we had. Like if I put you on the stand and you talked about how credible you are, and then I knew that you had been charged with perjury 10 times and I didn't disclose that, right? That's an actual potential Brady violation, something that actually would change the course of the trial, would change the way it was going. So first of all, the messages that they said they didn't have were not exculpatory. In fact, they indicated more guilt and said that
even Judge Arthur said that it perjures their witness and perjures Carly.
Yes. So first of all, you have to show that it's exculpatory or that it was intentional. So prior to, we were on a break and we come back and the defense attorney's holding these messages and waving them around. Most attorneys would have come up to us before the break ended and said, hey, while I was at lunch, I found this.
Mm-hmm.
Can you show me where this was produced? And we would have said, Judge, will you hold the jury back? Give us 15, 20 minutes. Let us go upstairs, show them where we gave them this. And then it would have been done.
Yeah.
But that's not how it was handled. Of course, on national television now, they stand up. We didn't get these messages. They withheld them. So I had never been more mad because that is an attack on me personally and could affect my entire career and my integrity. That's all I have in this profession. And also, we knew that we had turned it over. And so what you didn't see in the hearing was that before Judge Arthur came back in, his court reporter was sitting there, and I had shown Miss Todd and Kevin Camp where the information was on the external hard drive that we had provided them a copy of. And I said, well, would you like me to tell Molly to get Judge Arthur and tell him you want to withdraw your motion? And they said no.
Oh.
Yeah. Miss Bridget Todd doubled down and said, no, I want to see it on mine. And I said, okay. And she said, well, we don't have this particular phone extraction. And I said, yes, you do. And so I showed her on her computer, get out of that folder, get out of that folder. No, you're just looking at the screenshots. No, it's actually in this folder where it says phone. And then she opened it up. And then, of course, you kind of see that play out where Michael Smith, once it opens up in Cellbrite, Michael Smith shows her where that exact word and messages were, in fact, included in the discovery that they had received on June the 4th.
It brings up the questions. It makes you want to ask the questions. If you're not, you want to be as ethical as possible so that there is never anything that can point back to you being unethical and not doing your job right. An appeal could happen, things such as that. Yeah. And so it makes me question why double down?
Yeah.
Why?
Yeah.
It could not bear well for you going forward. And so I don't understand it.
Me neither. Again, we gave them the opportunity to withdraw the motion, and then to continue on. That part to me was shocking. And I've said this once before, and I probably shouldn't say it because it's sort of mocking their defense. But I said, I was disassociated at that moment. I truly was so mad that I did not know or remember what I had said.
Mm-hmm. I remember. I remember. But no, I think, and I'm not trying to say that they are unethical. either about, what I said earlier.
Sure.
I'm not saying that. And I'm not saying discounting them being good, ethical attorneys. So I'm just saying maybe there were some things in this case that could have been done differently.
Yeah, and look, I will say this. I look back on every case that I've been a part of, whether it's the defense side or prosecution, and I think, oh, well, I probably could have said this, or I could have done this differently. And so that's why I said no case is perfect.
Mhm.
I hope that they got caught up in the moment,
Yeah.
and thought that
And
they
that
were
happens.
yes,
It
and
happens.
thought that they were zealously fighting for their client.
Mhm.
That to me, there's a difference in being untruthful and unethical, and you can still fight zealously within the rules.
Yeah.
But again, I'm hoping that was a mistake that they will learn from.
Yes.
And that won't happen again.
Right.
And hey, anybody watching, if you think I hadn't turned something over, just ask.
Just ask.
Yeah.
So now we're waiting on Judge Arthur to do whatever he is going to do.
Mhm.
After that, you expect them to file an appeal, and at that point, are you out of it?
Yeah. So they'll have 30 days from any order that denies their motion for new trial or J&OV to appeal to the Court of Appeals / Supreme Court. They will file their notice of appeal, and then they kind of file their issues, and then the court reporter has a certain amount of time to get the record prepared. So the last thing that our office does is just kind of go in and make sure that the record that's being sent from the court to the appellate courts is proper, right? That
Mhm.
everything that they ask to be included is included. And yeah, then it goes over to the Attorney General's office. They have an appellate division there who is fabulous, and they will handle whatever the appeal is. Of course, they can call us and ask us questions, but really and truly that's what they do.
Mhm. And so are you hoping that happens? Are you ready to be out of the limelight? Let me ask you that.
Yes. I would like to go back to just trying my cases and nobody knowing who I am.
Yeah.
And
I don't know if that's going to happen for you, but because you did a great job in this, and just not, let's take away what it was, but the fight that you put, it was good. The going to court and watching you, and it was very professional. I'm sure everybody wishes it's something that would have never happened.
Yes.
I wish that Ashley was still here. I wish that Carly was still the innocent 15-year-old at home, making poor choices that every teenager makes growing up. Maybe not to the extent of others.
That's right. So sneaking out, vape pens, burner phones, those can all be chalked up as normal teenage behavior.
Right.
Grabbing a loaded weapon and shooting at not one but two people, certainly not normal teenage behavior.
Not at all. Which is another reason why I went home and hugged my kids.
Yes.
I love you.
Yes.
Please, I love you so much. Okay, so I really appreciate you coming. I want to check out our stream real quick and see if we got any questions here.
Sorry, I'm smiling because that's just my nature, not because I think that anything about this is funny.
Yes, I mean we're talking here. So let's see. Barbara saying Carly was 14. Let's not forget, and that is true. She's 15 now. She was 14 when that happened, and but in the state of Mississippi, she was charged as an adult, so her age really
that's right. Her chronological age, as long as it's over the age of 13, does not matter. In the eyes of the law, it's the same as if she were 18 or 38 or 48.
Mm-hmm, exactly. All right, let's see. Looking here. Somebody has a comment about Bridget High, but I'm not going to bring it up. I'm not going to. Here's a good question. Why was the jury the one who sentenced and not the judge?
So that's actually the new law. Says that for a juvenile tried as an adult and convicted of murder, in order to affix a life sentence, it has to be done by the jury. And so Judge Arthur could not have sentenced her to life. It had to have come from a jury. And the same thing for an attempted murder. And that's regardless of whether it's a juvenile charged as an adult or if it's an adult. It's life if affixed by a jury. And so that's why the jury handled it. Now, Judge Arthur did provide the sentence for the tampering with physical evidence instead of the jury doing that. And that's just because the law says that the court shall determine that sentence.
So when Kevin Camp was asking the jury to then put it in the hands of the judge, why was he asking them to do that?
because the judge could only give her up to 40 years.
Gotcha.
And to be clear,
and that's what she was offered, right?
Right. So we offered 40 years initially. And then I think it was the week before trial, we had a pretrial conference. It's usually about the week before. And Judge Arthur kind of pulls us all in the room and he says, both sides, if this can be resolved, don't be stiff-necked. What can you do? And so we extended our 40-year offer again, and then extended another offer that said we would let her plead open to the murder and the attempted murder, and let Judge Arthur determine her sentence. And they opted not to have that done, not to plead guilty, and rather to go to trial. As we've all seen, Ms. Todd had promised an acquittal. And so, at that point, 40 years is a long time. We're not pretending that it's not. And a lot of people talk about how could you do that to a child? What we're looking at is not a 15-year-old. We're looking at the heinous nature of the crime and how dangerous this person is. If she were to be released, if she kills her own mother over a vape pen, what else would she be capable of?
Right. And then she would be here in our community. And it is scary to think, will she get any help? Will she have access to help in the prison system, mental health?
Yeah. So she is in the juvenile portion out at CMCF, Central Mississippi Correctional Facility, and they offer mental as well as psychological help for anybody that needs it. And so whatever treatment she needs, she can get there. And then, of course, once she turns 18 and goes into the adult facility, those services can continue.
So she is not with the adults right now. She will stay in the division she's in until she legally reaches 18.
That's right. So any child that's been either pled guilty as an adult or tried and convicted as an adult has to maintain separate from the adult population. So it's a completely different building out at Central Mississippi Correctional Facility where they house juvenile offenders.
But she's no longer in solitary confinement.
No, that's right. And the reason she was in solitary is, thank goodness, Rankin County did not have another violent female juvenile offender. So if there had been another child under the age of 18 that was female, they would have been housed together in the same cell. She was just, so it wasn't like she was purposely kept by herself. It was just that, thank goodness, there was not another one there.
Okay. I didn't realize that. I knew that she was in solitary confinement, but I thought there was a bigger reason behind it. So it's just simply because there was no
other juvenile. So she has to be kept sight and sound away from the adult offenders while they're in the county jail. Mm-hmm. So that's why she was kept away from all other inmates. But yeah, had there been another, in fact, there were a couple of male juveniles that were bunking together because they were, both under the age of 18.
So you say she was kept away. Was there ever a time that she was with them, with the
adult offenders?
The adults?
No.
Because there was reports, or at least Kevin Gregg said that when Carly called him, that she was talking about they was calling her names, they were harassing her, they were being mean, for lack of a better word. But she wasn't around them. So how could that have?
She was not supposed to be around any adult offenders. I think that allegation came out at one of her prior hearings, and the defense attorneys said that it had been addressed. I don't know the merits of that. That's not something that we actually get involved in, right? That's the sheriff's department in the jail that handles that. But federal guidelines require that juvenile offenders being held as adults be kept separate, sight and sound away from all adult offenders. And that is for their own protection. And so, she was in isolation, but she had an iPad where she could communicate with people. She could get out each day, take a shower, make phone calls, in fact, I know that she was allowed visitors, and our jail actually doesn't do in-person visitors since COVID hit. But she was allowed visits after each hearing with her family as well.
That's good. That is good. Well, and I'm glad to know that she will be able to get help. Because while she may not have fit the definition of legal insanity, we know she has issues. She needs that help. She needs to see someone. She needs to be taken care of with mental health wise.
That's right, Garrett. And I think that can be said for a lot of our inmates, right? That there's some sort of mental health issue that they need help with. A lot of times it's coupled with substance abuse too. And they offer services for both. But hopefully, she will get the help that she needs.
Awesome. Well, I know that you have got to go back to work to some of the not as looked at cases.
Yeah. I doubt the national media will cover my next trial.
Hopefully they don't.
Yeah.
Hopefully they don't. Well, guys, thank you so much for tuning in for WLBT Plus today. Thank you, Kathryn, for coming in and speaking with us. We are definitely going to continue to follow this, and we'll let you know as soon as we hear something from a judge author, whether he calls them back into the courtroom or just says, nope, we're not going to do this. Well, we'll let you know. Thank you again for tuning in. I'll be back tomorrow at 1 o'clock for WLBT Plus. You guys have a great day. Bye-bye.